crossing live to Heidi Giokos. Of course, millions of votes may effectively be lost if the Electoral Amendment Act is implemented in its current form. That's a concern by the Independent Candidates Association. The matter did continue in the Constitutional Court today and judgment has been reserved. Let's take you live to Heidi Giokos now, just for a quick update. Heidi, we know that it was closing arguments today. The Home Affairs Department, which is essentially in charge of getting, a panel that will discuss this act, make sure that it's actually adequate for next year's elections. What did they say, or their legal team, what did they say in terms of their belief of the act as in its current form during their closing arguments?
Well, Maseko, I was hoping that the Minister of Home Affairs would be here today. He was here yesterday listening to court proceedings, but essentially the message is still the same from the legal team that's representing the Department of Home Affairs, and as you rightfully indicated, an independent panel needs to be appointed by October to overlook this Electoral Amendment Act and whether or not the Constitutional Court is going to rule on these two urgent applications that have been heard over the past 2 days. But essentially what the legal team for the Department of Home Affairs has indicated is that the current form of the Electoral Amendment Act in its current form is sufficient. It does allow for independent candidates to participate in next year's national elections, and the threshold that has been asked for, so the number of signatures that's going to be needed for independent candidates to register and contest next year should be moved from 15,000 to 1,000, and also the seat composition from 200 to 350. The legal team for the Department of Home Affairs is indicating that this is not really a fair request, and it's all about proportionality and whether or not an independent candidate should be contesting on the same level field or playing field as a political party. That is the argument here, and whether or not the Constitutional Court will be able to rule on what is actually fair here, because an independent candidate is one person and a political party it's a very different level that you're looking at here. But what is fair and what is constitutional, that is essentially what the department is arguing. Let's listen to what the legal team had to say on that.
So now we come to the nub of the debate, which is this an appropriate figure? And when I say appropriate, I use the word deliberately, because I go back to the submissions of yesterday, if anyone can remember that long ago, which is that this is an area where Parliament needs to be given some deference, where there is a range of reasonable options. And there's only one benchmark which has been put up in this case to suggest what an appropriate figure is. Only one. It wasn't put up by us. It was put up by Rivonia Circle. And that is the report from the Venice Commission. Now, I would ask the court, apparently the Venice Commission report is not actually before the court in its entirety, it's just quoted. I'm sure that the clerks will find it for the judges, it's not difficult. But if you read the Venice Commission report, start with the beginning, because the Venice Commission is it says we are trying to research elections throughout Europe, we're trying to do this, and we're doing a code, and it says the code is based on the underlying principles of Europe's electoral heritage. Lastly and above all, they constitute the core of a code of good practice in electoral matters.